Welcome back. Today we are in the middle of some high-stakes courtroom chaos. We've got two different cases here, but they both share one thing: a judge who is absolutely not in the mood for excuses. First up, we have Mr. King. He's facing prison time, and his defense? It's the classic, she's obsessed with me routine. But the judge is holding a PSI report. That's a pre-sentence investigation, and it says something very different. Buckle up, because the judge said is about to hit a legal brick wall.
All right, so this is the court's issue. And Mr. King, I'm strongly thinking of sending you to prison.
Miss Kiki Davis says that I kept blowing up her phone. That's a lie. Miss Kiki is still contacting me or trying to contact me.
My question is, how does it not make sense from me, but it makes sense from the attorney? You're being biased.
I'm done. You're not going to interrupt me.
You're very biased.
You're not gonna keep interrupting me.
Sorry, I was never trying to interrupt you. You're very biased.
Thank you.
You're very biased and disrespectful.
I'm done.
You're very biased, rude, and disrespectful.
Mute her and kick her out of the.
So he has a theft of service, DWI, in this case. And in this case, what I'm viewing is, number one, all of these grown adults who are living in the home, in his home, who shouldn't even be there. Get a job, go live somewhere else if you don't like the rules. On January 10th of no contest, you applied for deferred adjudication. The state was waiving the enhancement paragraph without objection. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. The state is silent on your application. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
All right, off the record for one moment, please. All right, have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections? State?
Not from the state, Your Honor.
Defense?
No, Your Honor.
All right, the state is silent. Defense, any witnesses?
No, Judge, I just have Mr. King.
All right, the court will hear argument.
On behalf of my client, Judge, if you notice from the PSI, it's been a long time since he's had any type of problems. And he hasn't had drug issues in several years. He's been gainfully employed at gyms, and he's dressed to go back to work as soon as this case is done, because he really feels that he could be a productive member of society. He is looking forward to trying to get his CDL license. He says you can drug test him, nail bed test him, hair follicle test him. He has been clean for several years. And this night, he was going to his girlfriend's house, and he didn't know that she had a new boyfriend. So I'm asking the court to consider putting him on probation or deferred adjudication. The deferred would give him a giant hammer over his head of 20 years if he violated any of the conditions. If he gets the probation, he says he can complete every term satisfactorily, and he's happy to go to any of the recommendations at the top evaluation.
All right, so this is the court's issue. And Mr. King, I'm strongly thinking of sending you to prison. I've read the PSI report, and I read the stipulations. And somebody needs to explain to me why I shouldn't send you to prison, because from what I read in the stipulations, she's saying that she's your ex-fiance, that you were calling her, as she says, blowing up her phone, calling her, asking her where she was. And then she says that he was looking for her to find this boyfriend that she was dating. And then she left her apartment door open, and he went into the apartment door, and then he beats up the boyfriend, who he said he was dozing off on the couch or something. So that's what I have before me. And it's...
Ouch. Did you hear that? The judge just dropped the S word. Stipulations. In legal terms, when you stipulate evidence, you're agreeing that these facts are true for the record. Mr. King's lawyer is telling a story about a car and a misunderstanding, but the signed paperwork says he broke into an apartment and beat a man up. Pro tip: never try to out-talk your own signed confession in front of a judge who actually reads the files. Do you think he's digging his own grave here, or is there a chance his side of the story holds water? Let me know in the comments.
It's been stipulated to. So, counsel, now you're saying it's something different, but that's not what's in the stips.
Mr. King would like to address the court.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Herbert King.
All right, any questions?
He would like to just explain to you to answer your questions.
Okay.
Miss Kiki Davis says that I kept blowing up her phone. That's a lie. Miss Kiki is still contacting me or trying to contact me on a constant basis. Where I stay at, they know the whole situation. So they advised me to not be in contact with her. She literally came to my new job before and asked somebody to have me to step out, and I wouldn't step out. So she's constantly bothering me, wanting money from me, wanting me to go take care of her dog that we bought, like telling me she's not with this guy. And with the thing with the guy, he had been harassing me for months, picking on me. When I went to her house, all I did was go to pick up my car that she told me to come pick up. My sister couldn't be in court with me today. My sister is a witness to it. My sister told me not to go. And I was like, I'm just going to pick up the car. She's not going to do nothing wrong to me. And I just went to pick up my car. Then my money from work comes on.
So how did this result in an altercation with this guy?
I was standing out talking to her at the car. And at the time I was talking to her at the car, he came out behind me. I had my back turned and he tried to stab me with a box cutter. And of course, I'm a man. I'm going to turn around and fight. I'm not going to let you just stab me. And it's funny to them now. He done called me on numerous occasions since I've been out on bond. I called the police. The police basically told me he can call me at any point he wants to, but I can't call him.
Where's the proof that he called you?
Miss Kiki Davis pops up in my house one day when I wasn't there.
No, you're skipping over my question. My question is,
I had a phone with all my information in it that when I went to jail, I went and got it. I tried to give it to my previous lawyer. She kept blowing it off, blowing it off, blowing it off. I can't get it now. The court has to ask for it. And one day when I was at work, Miss Kiki Davis came to my house, told him she was getting some property that belonged to her. My friend doesn't like problems at his house. He tries to give her the phone or whatever she was in there trying to get, and my phone and stuff came up missing. But I'm not bothering anybody.
See, here's the thing. The stipulations say something completely different than what you're telling me. The stipulations say that her boyfriend or fiance, whomever he may be, was inside the apartment and that you beat him up inside the apartment. You're saying that she's come to your job since. Where's the proof of that? Because the stipulations say something different. Then you're saying that he is calling you. Where's the proof of that?
He's calling me. I called the police. I made police reports on it, and they gave me a little paper. I don't know where the paper went.
Once a police report is made, it should be in the system.
And the police basically told me he couldn't really file a report because the thing was against me, not against him. So he can call me at any point that he wants to.
All right.
The judge is leaning towards prison, but she's giving him one final Hail Mary pass. She wants proof. In the world of law, he's mean to me is a story. A police report is evidence. She's literally giving the defense a month to find receipts. This is a massive turning point. If they can't prove the ex and the boyfriend were harassing him, Mr. King is trading his civilian clothes for a jumpsuit. It's all on the investigator now.
So, counsel, this is Mr. King's story. Right now, I'm leaning towards sending him to prison. But if there's something that's produced to the court that this complainant in this case has been calling him, I would say because his ex-fiance, the fact that she's going to his job, if he wants to bring in information or somebody who knows of that, I will listen to that. But most importantly for the court, because this is really a case against her boyfriend, I want to know if the boyfriend has been contacting him as he says he has, and some proof of that. Because otherwise, I'm leaning towards sending you to prison because this is a serious case. And based upon the stipulations, and your attorney will tell you, I always read the stipulations and I always read the PSI report. And I know in the PSI report, nobody's been able to get in touch with the complainant, but your client is saying that he's been calling him. There should be some record of that.
Okay. How much time can you give me? Because I would have to contact the police department and get a copy of the report and then see it. I don't know about any phone being improper.
It was a different phone.
But if there's a more recent phone, I can try to on messages or things like that and see if I can bring in somebody from his job to come in.
Yeah.
That's fine.
And State, I know you're silent on this, but I would really like to hear from this complainant.
Yes, Judge.
All right. So how much time are you asking for?
Can I get them on?
Yes. All right, Ms. Ferguson or Mr. King, can we recall this for 1 month, please? No, put it, can you put it on like maybe the 24th? Because that's when I can hear it.
Okay.
So we'll come back on April 24th. And I will remember this conversation, but so everybody else can remember it, I will write on the docketing sheet what I'm asking for. And what I'm asking for is your ex-fiance coming to your job. That's great. If you want to bring somebody in and say that she's coming to the job, that's something for me to consider. But what I really want is I want this information about the boyfriend who may or may not still be her boyfriend. I want information that he is actually been calling him and state if he can come in. Yes.
She has problems with all men that she's with. He actually beat her up 2 weeks after I was out of jail.
Oh, well, see, here's the thing. That's
that's what I'm saying is,
if you want to bring a police report on that too, you're more than welcome to bring a police report on that.
I will see what I can get you.
All right. But I just want everyone to know what I want.
yes, ma'am.
Okay. All right, Ms. Ferguson, we'll give you a reset form and it will be at, let's set it for at 11.
Okay. Judge, on this case, I did not have an investigator appointed. Can I get an investigator for a short amount of time to find those records for me?
Yes.
Okay.
And counsel, if you, because I know you haven't filed the motion yet, if you just get the investigator and then you can bring the motion in and the court will sign it. That way it can start immediately.
I'd like to do that.
All right. And do you need do you have a copy of the police report or do you need it for the complainant's information?
I have the discovery, so, but I don't know how contemporaneous that would be in terms of getting her phone number because he says it's changed.
Okay.
But let me see what I can bring in to show further proof of what he's telling me.
All right. Thank you.
Thank you. Thank you. More in a minute.
All right. So what does he do now? Is he allowed to go? He goes to work.
Goes to work and home.
All right. Have there been any issues with the GPS?
Not that I'm aware of. I've not gotten any reports on him.
All
I
right.
was not the attorney before. But since I've had him, he's had no issues.
All right. So counsel, this is what the court will do. If you are able to represent to the court, and I know you'll have to look into it, whether or not he's had any violation. If he's had no violations, then what I will do is I will allow him some leeway other than work. For example, his personal needs, like if he needs to go to the grocery store or something like that, and I'll give him a window where he can go to the grocery store, go to a restaurant or something of that nature.
Do you want me to submit an order or do you just want to write it on the docket sheet?
Well, if you can present to the court.
I can have him testify under oath that he's had no violations and I've received nothing.
No, that's his testimony is not good enough for the court. But I will tell you this, the clerk is in the back and the clerk will be able to tell you if there have been any violations because I would have received it.
It's under the court clerk. She reviewed all of the criminal history on the sieges and she says there have been no violations pre-trial at all.
All right. Well, if you want to discuss with your client what day he would like to have extra time.
Can you come up here and ask?
Yes.
Okay.
So okay. No, I'm not going to remove the GPS tracking. So you're going to be allowed still to go to work, but I'll give you 1 day out of the week where you can have some extra time that's maybe outside of work hours for you to go to certain places, but there'll still be a no contact order in place with the ex and the complainant.
Yes, ma'am. That's fine.
So what you need to tell me what day of the week. All right, state, Mr. Gerhan. So he's still going to be on partial for work, but I'm going to give him an extra time on Sunday. So what type of curfew do you all want on Sunday?
Well, church apparently lasts a while. So
Which church is it? Is it Baptist church?
Yes, ma'am.
All right, so that I know.
so if we can have
It does.
it does. If we can
Well, do you know?
I do because
You belong to the Baptist church?
I do not. I'm Catholic, but
Yeah.
I've gone to different events and funerals, etc.
Well, as long as
it
it's
takes a bit.
now, as it's the pastor's anniversary, that's till 8 at night. But Sean, you know, right? So, but nobody is allowed to leave for the games on Sunday because, yeah. So, how much time are you asking for on Sunday?
Just because I work Sunday night, so I'm just trying to get out Sunday morning just to be able to go to church.
Well, I mean, you got to give me some time. So, like, when does service begin? Are you going to Sunday school? Okay, so
I always get a whooping when I go to Sunday school.
all right, so
From about 8 to 12.
8 a.m. to 12 p.m. All right. So are you going to be do you need to be someplace at 8 a.m.?
No, this church.
All right. So then, since you're saying 8 a.m. to 12 p.m., I'll give you 7:30 a.m. to 12:30 p.m. on Sundays. And counsel, if you could go in the back and have them print me a B page, I'll write that down. State, are you okay with that?
Yes, Your Honor.
Okay. If that has a seat on it, if you would like to be seated, that's fine. If that will help you.
I think I can stack.
All right.
Just a little bit of pain.
All right. Court is calling 2023 CR 0683, State of Texas versus Mario Miranda. Can I have parties announced for the record for the state,
Not done for the state.
for the defense?
Michael J. Sawyer.
Are you Mr. Miranda?
Yes, ma'am.
You entered a plea of no contest on May 17th. According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. The state opposes your application. There's an affirmative finding of family violence. There's to be no contact with the complainants. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, defense?
Just one discrepancy in an account, and we have a copy of that report that was filled out by SAPD Patrolman Torres.
Mhm.
State has given a copy of that report this morning. And does the court have a copy of that in their possession as part of the PSI?
Yes, I have a copy of the PSI. If you'll direct me to what page?
Well, I'm looking at it. Judge, look at that report.
No worries.
So John, simply give the court the report. The state will not object.
All right, I have a copy of, the police report.
Police report, yes, ma'am.
All right, and this is defense exhibit number 1, the defense. You're not offering into evidence. You're just asking the court to review.
That is correct. And I have a couple of questions about it. And I said that believe the court can review it,
Yes.
see the discrepancy.
All right, court has had a chance to review.
And that's why I'm pointing to the court. Nick Miranda, who was there, told Officer Torres, one of the first policemen on the scene in that report, that he disarmed the defendant in the bedroom at the very onset. It's in the report.
All right.
That's all.
All right. Any evidence, state or defense?
No evidence from the state.
Nothing further from the defense. I think most information the court needs is contained in the PSI. We have reviewed it. It is accurate. It looks at his prior criminal record here, California, Medina County, and it's true and correct in our opinion.
All right.
Transitioning to our second case, Mario Miranda. The prosecution is painting a picture of a man with zero remorse, claiming he almost killed 2 people. And the motive? Get ready for this. A taco Seriously, the state is arguing that a disagreement over breakfast almost turned into a double homicide. This is why we say the truth is stranger than fiction. But wait until you hear Mario's side. This is where the family drama gets really messy.
All right, then, State, you're opposed?
Yes, Your Honor.
And if you would like to present your argument?
Yes, Your Honor. So we'll present, we thank you for the opportunity for just a brief argument. And this is an individual, Your Honor, wherein lack of accountability seems to be kind of first and foremost here. You have their partner, which, said he, friends have told me he's looking for me. I believe he's going to kill me. He's a very violent man. You have her son saying he's the type of man that, again, will come and find us. He's threatened to kill me. No care, no remorse, no sympathy, no empathy. And even in the defendant's version of events, there's just a complete lack of accountability.
Well,
all of this is based on lies. I don't want probation, but I don't want to go to prison. So not only is there no accepting of consequences, there's no actual acceptance of what's underlying. And again, I think you have two complainants wherein the version of events, as is noted in the stipulations that the court has reviewed, and it is noted in the PSI, it started over something pretty benign. I think that's what bothers the state the most. This was over a disagreement involving a taco. And then after that discussion, defendant has his version, but through pre-trials and all the discovery given to defense and the police reports and the other evidence that was disclosed over the defense, a pretty clear version of events is that if the young man had not taken this individual's gun away, two people might be dead. And so given their complete lack of disregard or complete lack of regard and a disregard for human life and for consequences, that is the in summation, the state's opposition to probation in this case, Your Honor.
All right, so here's my question. And if you could raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Mario Miranda.
All right. So, are you currently living in Bear County?
Yes, ma'am.
Who do you live with?
No. Pardon me, ma'am?
Who lives with you?
Just me and my girlfriend and my oldest son.
All right. So how do you know the people who were involved in this?
How do I know? She was my ex-wife and divorced in '93, and that was her other son that she had while we were married. Was my son. And well, she had the audacity to go have that son under my insurance, under my hospital from the VA.
All right. So here's the thing, mother's baby, father's baby, but that's all on you because you allowed that to happen. All you had to do was a DNA test. So we're past the point of you're trying to seek sympathy for the court because you've been paying for a son who's biologically not your son. I'm trying to figure out who were all the people who were in the home and were you all living together when this happened?
Yes, ma'am. I had my two sons and her son and her, and nobody was paying except for me.
Nobody was what?
Paying, for nothing.
All right, then you should have put people out. They're all adults.
Yep, exactly. I should have put them out. But I had compassion for especially her because she was renting an apartment with my oldest son, and they lost the apartment. They got evicted, and she was supposed to have heart surgery. She hasn't had heart surgery since then. It was all a lie, I think.
All right, and what is this about a taco? State says
the whole thing happened. We were having a yard sale, and she was there with her sister, and she said, "There's nothing for breakfast." I said, well, "Okay, fine. I'll go to H-E-B and get this stuff." But she said, "Well, I'll cook for all of it." Well, it turned out she cooked for everybody else except for me. And I said, "Thank you for the taco." That's all I said. And then she started at me, and then all of a sudden, I got her son on me. And he got up like he threatened me and said, "You owe this and that, and vulgar language. I'll do this to you right now." And he's a weightlifter in MMA. See, and that's what I was afraid of, that he was going to get me. So I went to my room. I got my gun and I was going to leave the house. I was going to holster my weapon,
Mm-hmm.
and I was going to leave, but I still had a license to carry and everything, and I was able to defend myself that way. I couldn't fight with a young man like that. And I was going to leave the house, but then as I was going out, after the weapon was taken away from me and everything, then he assaulted me in the kitchen. And when the officers came, she right away, my ex-wife, right? She right away started saying he was pointing a gun at me and my son, and it was only him. I mean, my other son was there, and he's the one that took my weapon away from me. And that was taking it out of the pouch. And as soon as I got out of the pouch, he had the gun in his hand. So there was no assault there. And she lied, I mean, for the longest time. She's been trying to get my money out of the VA also, saying that she's my common law wife. And in all the report that she makes, my husband. I'm not her husband. You know, divorced her back in 93.
Okay. All right. Any questions?
Would it surprise you that the version of events, again, this was all disclosed to counsel, that the complainant, the young man, said that the actual version of account is that you got home angry and that you were yelling at Maria and they said, lay off her. And you said, well, don't tell me nothing because I'll put a bullet in your head if you don't shut up.
Oh.
Does it surprise you that that's the account that was given to the state?
That's a question. He's asking a question. He wants you to answer it.
The question is, does that surprise you that that's the version or the account that was given to the state?
I didn't know about that. That's why I didn't know nothing about that.
My second question is, if you were so intent on leaving, right? So the door to the outside where the garage sale was happening,
Yes.
was right next to the kitchen where the stove was. But instead, you chose to walk all the way down the hall past 3 bedrooms to the last one on the left to then retrieve your gun. Isn't that correct?
No. The gun was in the last bedroom. That was my bedroom.
Correct. The gun is in the last bedroom on the left. Yes or no?
Yes, he went there. Yes.
Right.
He followed me from the dining area to the room, and so did she. And then my other son, middle son, Nick, he's the one, when I was taking out the weapon, that he took it away from me then.
So if Nick hadn't taken the gun away from you after you threatened 2 people multiple times to shoot them in the head, do you think they would be dead had he not taken the gun away?
No, sir. I never made any kind of threat.
No further questions, sir.
All right. So I will tell you both. This is what I'm reading in the police report, and this is a witness. And it's witness 1, and it's on page 2 of the police report. It says, on July 16th, I called witness 1 for a statement and conducted it over the phone. Witness 1 said he initially heard arguing between AP and victim 2. His brother, victim 1, then intervened and began arguing with the AP. And your client, of course, is AP. Witness said that victim 1 told AP that he needed to be beat up for the way he was acting. Witness 1 believes this sounded like a threat to AP. AP then went into his bedroom. Witness 1 heard victim 1 yell that AP was going to get his gun. Witness 1 did not hear AP verbally threaten victim 1 or victim 2. Witness 1 said he saw AP take his gun out and point it sideways. Witness 1 quickly pulled AP's arm up in the air and got the gun from his hand. Witness 1 did not see AP point the gun directly at victim 1 and 2. Witness said he then went to go hide the gun in a box. Witness 1 stated while he was hiding the gun, another argument started in the kitchen. Witness 1 said he walked in the kitchen and saw victim 1 on top of AP1. On top of AP. Witness separated them and asked for police to be called. So that's what witness one is saying. Is there anything else from either side?
No, Your Honor.
Nothing from the state, Your Honor.
All right. So this is one.
This is a major pivot. The judge just listed off 26 different medications and a laundry list of mental health issues, including PTSD. In legal sentencing, this falls under mitigating factors. While the crime, aggravated assault with a deadly weapon, is incredibly serious, the judge is looking at the whole person. She's weighing the danger to the community against the fact that this man is a veteran who is clearly struggling physically and mentally.
This is what the court is going to know. Because this case, is it a difficult case for the court to make a decision on? Yes. But what I have, the person I have standing before me, based upon the PSI report and everything else, it shows that he is a veteran. And then let's see, where did here we are. On page 6 of the PSI report, he is on no less than 26 medications. And he has several mental health issues. He has PTSD, neuropathy in both legs, osteoarthritis, knee replacement, hypertension, type 2 diabetes, benign prostate, hypertrophy, gastroesophageal reflux disease, hyperlipidemia, hematochezia, tuberculosis of the colon, hearing loss, erectile dysfunction, cardiac murmur, anemia, microtysosis, bilateral cataracts, cherry angioma, polymyalgia, rheumatica, hemorrhoids, depressive disorder, psychotic disorder. And then they have him on 26 medications. And what I'm reviewing in the police report, I understand that the charge is aggravated assault with a deadly weapon. I understand that the defendant has entered a plea to aggravated assault with a deadly weapon based upon what witness one is saying and the other witnesses. I believe the truth is somewhere in the middle because the defendant has his truth. The complainants in the case have their truth. And usually, sometimes it's best to get truth from witnesses because they technically may not have a dog in the fight. But I do understand in this case, some witnesses were what he says, his children. Some witnesses was her child. I understand all of this. So the way I see my job is one, what is the appropriate sentence for him? And also protect the community. And protecting the community means protecting the people who are the complainants in this case.
And Your Honor, may I speak just
Yes.
very, very briefly? I believe in terms of what was just spoken about even today, there seems to be kind of two
Camps.
No, camps, absolutely, and almost two events within one day, wherein the allegation of the aggravated assault via pointing the weapon, and then the kind of scuffle after the fact.
Yes.
And I just so that it was, I think, more clear on the state side, and I should have done this sooner, but even the eyewitness, so the two complainants and eyewitness, quote, he stated he observed S1 retrieve the gun and point it towards the victims. And then later in that paragraph, he said he did not, quote, I did not observe any physical assault. So even the eyewitness, there's no question, again, in terms of the state's perspective on the pointing, but absolutely cannot corroborate with respect to eyewitness testimony, the latter scuffle, if you will.
Oh, no. And I understand all of this started over taco.
Yes. And they would fight like that all the time. I'm sorry, ma'am.
All right. So my understanding is like the individual children who are involved are adults. The other complainant is his ex-wife. They don't have any young children where there needs to be any sort of custody arrangements. There's no need for them to have any contact. I can give him deferred adjudication, but He is not allowed to have possession of any weapons, period. You say,
If I may, I had a long discussion with my client about that. He agrees. Any condition imposed by the court, he will follow it.
Yes, ma'am.
all right, so I'm telling you, and I look at his criminal history, and this is his criminal history, this case. I don't, and of course he has a previous, driving while intoxicated. So his history is driving while intoxicated in this case. And he's done probation for the driving while intoxicated previously, and that probation was terminated. And I'm sorry, he had a theft of service, which is with a check, where he wrote a check and didn't pay. So he has a theft of service, DWI in this case. And in this case.
And there it is, deferred adjudication. Basically, the judge is saying, I'm not sending you to prison today, but if you even look at a gun, you're done. She summed it up perfectly. Everyone in that house is an adult, and the drama was fueled by a toxic living situation. It's a classic get your life together ruling. What do you think? Was the taco defense and his medical history enough to justify him staying out of prison? Or was the threat of the gun too much to overlook? Drop a balance scale if you agree with the judge.
What I'm viewing is, number one, all of these grown adults who are living in the home, in his home, who shouldn't even be there. Get a job, go live somewhere else if you don't like the rules. I understand this was an issue over a taco. Mm-hmm. You have the issue of the taco compounded by their having a garage sale, and garage sales never go the way people expect it. They always think they're going to make a lot of money. You pay for your permit and then you make maybe $2. So we have that going on. And then we have the PTSD with him. And then we have all of these medical issues. I just don't think this case is necessarily a prison case. And honestly, I don't think he would survive in prison. And when I say survive in prison, I mean because of all of his medical issues. And that would cost the government more money to place him at the prison. All right, this is what the court is going to do. There's going to be an affirmative finding of family violence. The court is going to sentence you to 5 years deferred adjudication. There's to be no contact with the following. There's to be no contact with Jonathan Garcia and Maria Garcia. The court notes that you're receiving your benefits from the VA and also receiving other benefits. You're going to need to provide that to probation. So, Ms. Abrams, I don't believe he's able to work based upon all of his medical conditions. So he'll just provide proof of VA benefits to probation within 30 days. There's to be regular reporting by Zoom or in person. There's to be regular UAs, although, Ms. Abrams, I think that UA is going to be filled with positive based upon all the medications. You're going to need to provide probation with a list of your medications. You understand?
I already have them.
All right. No, listen to me. Provide them with a list of your medications. Right. And let me see. All right. There's going to be outpatient treatment with the VA. There's to be weekly sober meetings with the VA until further notice. I'm not going to order community service hours. I don't believe he's able to complete community service hours. Is there any objection?
Not at all.
None.
All right. There is going to be field visits, random, one time per month until further notice. And probation, if you could let the officers make sure that there are no weapons in that home. Probation, is there anything else? Yes. You're not allowed to possess any weapons. Do you understand?
Yes, ma'am.
All right. Is there anything else you need from the court?
Oh, Matt, I don't think so.
All right. Did you review the document entitled Trial Court Certification of I'm sorry. There's also an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Did you review that and sign that?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Miranda, here's the thing. If you cannot get along with people, you shouldn't let people live with you. And you're not to have any contact with them. If you end up having contact with them, a motion to revoke is going to be filed, and you're looking at 20 years in the prison. Do you understand?
Yes, ma'am.
All right. Do you have any questions about my instructions to you or what you need to do?
Them showing up in my home.
Call the police.
Okay. I understand.
All right. You'll need to call the police if they show up. You understand?
Yes, ma'am.
All right. Thank you.
All right. Thank you.
On behalf of my client, and thank the court for the consideration today.
All right. Thank you. Have a good one. Oh, and Mr. Sawyer, how's your wife?
Very much better. Thank you.
All right. Awesome.
Making my life a lot easier.
All right. Have a good one.
Thank you for asking.
Thank you, Ron.
I know that. I'm so much here.
What's your name?
Here, Morris.
All right. This is your request to set aside default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed some to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor, when looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was
Yeah.
unaware of the
Okay.
hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time to, I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go up.
First of all,
I'm sorry.
there was, so, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
It's
Lawrence
absolutely
was
not true.
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can pull up the ones that I have and I can send it back into the court.
Ma'am,
So
I have your signature on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that. So you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So, I'm confused on the motion. It did not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes,
So-
I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they need to train staff, and we're trying to come to a resolve. So my information hasn't changed, and my issue hasn't changed either. And if we would have been in court in May, because that ledger says I had a balance.
Ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account, and that's why they dismissed it.
Correct. The same day, Judge. Ms. Dornbush is not acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of 2025.
Do you see that on the account, Ms. Dornbush?
I do see that, Your Honor, and I believe I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it, and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's the whole 12 months. So I understand
what is her current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in.
I know that.
Okay,
so
I'm saying
you tell me, taking out all of that, how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as well.
I got $700. So you're saying that if I take that $700 off, add the $300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not.
You can say absolutely not.
Where is that going to come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right. So in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they did
$85 per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is 55 that gets charged on after the 5th, and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Ms. Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So,
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen to me.
If you look on my ledger,
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm asking you for where that discrepancy is.
Okay,
You
sir.
are giving me 150. I'm not agreeing with you. I'm just saying, where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I'll go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out a letter saying I owe $160.
Ma'am. You are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You have given me a total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow in November. My rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. all of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
Ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can
It's the
send it back
motion
in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it make sense? Not make sense for me, but it makes sense from the attorney. You're being biased.
I'm done. You're not
You're
going to
biased.
interrupt.
You're very biased.
You're not going to keep interrupting me. Motion
Sorry, I was
denied.
never trying to interrupt you.
Motion
You're very
denied.
biased.
May issue. Thank you.
You're very biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful
I
and
am
you're very
done.
biased. You need to do your job. You don't know how to do your job. That's
Mute
all.
her. I am done. Motion denied.
Your Honor, I would request that the monies held in escrow. I think Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her